In rural areas of the state of Maine, there are not enough public schools. In some school districts, in order to enable children to attend school, Maine established a program that would pay the tuition of students to attend private schools. However, Maine had a policy of withholding this funding if the private school used any of their property for religious purposes. As Maine's lawyer before the Supreme Court explained, the issue for Maine was whether these private schools were teaching religion to their students. In the United States, a private school is a type of nonprofit institution that is not owned or operated by the government. Most often they are organized as a legal entity referred to as a 501c, specifically a 501c3, a type of corporation that is not taxed because it is not intended for profit, but to promote a, quote, public good. This is the same for almost all private schools, regardless of their religious affiliation or lack of religious affiliation. Churches are another type of nonprofit organization that are often organized into 501c3 corporations. Schools and churches are very rarely part of the same corporation and so are legally distinct entities, the same way McDonald's is a separate company from Coca-Cola, even though McDonald's exclusively serves Coca-Cola. Under the Establishment and Free Exercise Clause of the First Amendment to the United States Constitution, Congress can make no law respecting an establishment of religion or prohibiting the free exercise thereof. Though originally this only applied to the federal government, through the 14th Amendment this clause has been incorporated or enforced upon the states, and so a state can likewise make no such law. The question before the Supreme Court was whether Maine's withholding of these funds violated the Establishment and Free Exercise Clause by offering tuition payments to private schools but explicitly and only denying those funds to private schools that taught religion. The core of the matter here is on what basis Maine was making its decision, and the state was not shy about acknowledging that the issue was whether the school taught religion. During oral argument before the Supreme Court, the Chief Justice illustrated the root of the question well.
Counsel.
I'm sorry, Chief, after you.
Let's suppose you have two schools. School A is run by religion A, and that religion has a doctrine that they should provide service to their neighbors. So they're set up and running a school. But there's nothing in their doctrine about propagating the faith or whatever, so it does look just like a public school, but it's owned by religion. Religion B also has a school, but its doctrine requires adherence to educate children in the faith, and the school is infused in every subject with their view of the faith. Now, would the first school get the funds?
Yes.
Okay. Would the second school?
No.
And that's because of the difference between the two religions, right?
That's because their program is specifically instilling and promoting religion in students.
And the other religion does not.
That is correct.
So you're discriminating among religions based on their belief, right?
No, I would not say that. Religions can have whatever belief they want, but if they want to take part in Maine's tuition program, the education service they have to provide has to be the service that Maine is purchasing.
Well, and one religion says that's what they do with education, and the other religion says, no, we use it to propagate the faith. So it is the beliefs of the two religions that determines whether or not their schools are going to get the funds or not. And we have said that is the most basic violation of the First Amendment religion clauses, for the government to draw distinctions between religions based on their doctrine.
Discrimination is the act of choosing something. Certain types of discrimination are illegal under United States law, such as discriminating based on race, gender, or religion. In this instance, Maine was discriminating on the basis of whether a school was religious. Maine did not claim to have any other basis. They simply asserted that they had the right to discriminate on those grounds. The Supreme Court held in their opinion released on June 21st that Maine could not discriminate against religious schools on these grounds. What this means is that states across the U.S., if they have a tuition assistance program or if they have a funding program for private schools, cannot withhold that funding from a school on the basis of it being religious. Many people have confused this ruling to mean that the state must fund private religious schools, or that this means the state must fund churches. Neither are correct. The state does not have to fund private schools at all, but if they do, their basis for denying those funds cannot be religion. And as mentioned before, churches and schools are separate legal and financial entities. There is no question of a separation of church and state arising from this case.